What a lovely day it is, eh? Look at all the buttercups out. Ted, where are you going? Right, I thought I'd quickly come on and just have a little chat about justice system, the great British justice system, and what happened yesterday. So this padlock, a £50 padlock that got cut through with a grinder on the 16th of March 2024, that Kent Constabulary joined forces with Wilson and Row High Court enforcement at 4 o'clock in the morning to meet up on the 17th of January to come and arrest me for this alleged offence of criminal damage to the padlock, which is 10 months after the offence, the alleged offence. So they'll put it down as a Section 1 and Section 4 of the Criminal Damage Act. Section 1 is to cause damage to property to a value without lawful excuse, to cause damage to a property for under £5,000. Section 4, which is arson, which brings into aggravated aspect of it. Now, in the prosecution papers, which I finally got 46 days after the first hearing, when I went to court on the 28th. So I went to court on the 28th, took a witness statement from the homeowner. The judge read the witness statement and he said, well, you had lawful excuse to do what you did. I said, yeah, I know, there's no case to answer. He said, so you'd be entering a not guilty plea. I said, no, I won't. I said, there's no case to answer. He said, we'll enter a not guilty plea for you. I said, well, if you're going to press to go for not guilty, then, and to push it to trial, then I'm going to elect to go to Crown Court. He said, you can't do that. He said, it's a summary only offence. I said, well, that's not what the charge says. He said, well, it's under £5,000. He said, it's a £50 padlock. He said, so it's a summary only offence. I said, excellent. I said, that's even more reason why there's no case to answer, because it's statute barred. The alleged offence took place in March. It wasn't reported till December, and I was arrested and charged on the 17th of January, 10 months after the event. At that point, there was no prosecution papers given, so I directed the CPS that they needed to respond to this allegation in substance to clarify or quantify how this was an EVI offence. Anyway, judge ordered them to provide the evidence in 28 days. They never. I put an application on the 31st of March to dismiss the claim, which was just completely ignored. Chased the court up, chased the CPS up. CPS provided the case papers 46 days after the 28th of February, not 28 days. And like I say, when I went through the paperwork, there's no evidence of any aggravating factor at all in there. And it's a £50 padlock, which is evidently clear, which I've posted up on my wall with a witness statement from this Goldstein. So now we got the judge telling me it's a summary only offence and I had lawful excuse to do what I did. So I went to court yesterday. I put a final position statement in relation to the matters. I went down to the court. The judge come out and said, I said, right, all I'm here for is to deal with my dismissal application. He said, no, we haven't got time for that. So what do you mean you haven't got time? I said, I'll put the application. Well, the CPS need time to respond. I said, well, they've had plenty of time to respond. I put the application on the 31st of March. It's been completely ignored. They knew about the hearing, which is here today. Well, no, what I'm going to do is I'm going to give you 4 weeks to provide a skeleton argument, no more than 8 pages, to provide it to the CPS. And then the CPS can then respond in 4 weeks, and then we'll set a date. And I said, well, no, because we need to establish jurisdiction. The court hasn't got jurisdiction because the matter's, it's a summary only offence. No, it isn't. I've looked into that. She said, and under the statute, it's not. It's an EVI offence. I said, well, that's not what the judge said on the 28th of February. He said, well, the judge got it wrong. I said, how can the judge get it wrong? I said, it was the judge and the court clerk that stated it was a summary only offence. Well, no, I'm stating that it's not. It's an EVI offence. So what we're going to do is we'll set it for a hearing. Can you have a look at the hearing times? So I said, I don't need 4 weeks to provide a skeleton argument. Everything I need to say is in my document, the dismissal application or dismissal position statement, which I've given and served to the court and also to the CPS. I said, I don't need any time. Everything I need to say is in there. I said, give them 2 weeks to respond to that. No, I'm going to give you 4 weeks. I'm going to give you 4 weeks. I said, I don't want 4 weeks. I said, justice delayed is justice denied. I said, it's been going on long enough. So with that, that's what they've done. So they've set it for a hearing date in February 2026 to hear my position that the claim is the claim's a fraudulent claim and to deal with the jurisdiction of the case. So this is why the justice system, this is why the CPS have got full knowledge that that they've got no grounds, there's no substance, there's no substantive reasons for it to be an either way offence. And it was only when I threatened to take it to Crown Court is why they obviously kept it in the summary. Now, what this is highlighting is that the police, the CPS, and the magistrates' courts are all working together in collusion. There's no other reason for it. There's no other justification for it because it's a £50 padlock. There's no aggravated factors of it. It's a summary only offence. But what you've got to look at is the reason why they're holding on to this like a vice as to be an either way offence, which goes to Crown Court. We're looking at, 4 years before that to get resolved there. If the court and the CPS drop this summary only as a summary only offence, which is what it is by law, you do your own research, I've done mine, is if they drop it, that throws the police and the bailiffs under the bus, which means that the police had no lawful legal right to be at my property, to be shutting my road off, to meet in with the bailiffs at 4 o'clock in the morning in the planned operational attack called Operation Zloti, to assist the bailiffs in stealing my home over this padlock. A £50 padlock. I stated to the court, this is not in the public interest. It doesn't pass the public interest tests. I said it's a complete waste of the public purse. Won't have none of it. But still smiling. It's still sunny, and I'm not surrendering. Listen, I'm standing on the truth. When you stand on the truth, you can't be moved. And what is being done is malicious. It's a malicious prosecution, a targeted attack to protect the banks, the police, the courts, the CPS, the bailiffs, and in the asset stripping. So yeah, read into it. It's a £50 padlock. I'm going to put some more posts up about it. I'm not waiting until February. You can't. They've got no jurisdiction. The court had no jurisdiction to hear the case. And that's not even getting into the fucking misidentification of the parties and not even getting the name right. But yeah, listen, enjoy your bank holiday weekend, everyone. I will, and I thank you all for the continued ongoing support. It does mean a lot to me, and I mean that from the bottom of my heart. It's them, it's us, and the truth will set you free. Have a good day. Cheers, guys. From me and Ted.